Thank you for watching the World Community Magazine's Hour of Power Live on Facebook with your hosts Edward McQueen and April Garner.
Oh, wow. This is a fine time for us to come on live. Day after tax expiration date.
Oh, yeah. Don't talk about taxes and tax people. Don't
talk about that. But
the deadline was yesterday.
It's the worst part of the year. Well, those days are accumulating up to that. Good evening. How you doing, April?
I'm great. How are you doing?
Miss Garner Davis. Guess what? Speaking of taxes, okay, we as most people seen of our promotion here, we're not going to directly talk about taxes, but a lot of people getting refunds. I'm not one of them. so as I said, this is the worst time of the year. But those of you who are getting refunds, we're going to find out what you can do with that money. But you got to leave a will. Is it enough to leave a will in? I'm starting off kind of jovial, but this is going to get some real serious stuff, and I hope everybody has their questions and comments they want to send in to, okay? Because this is something that most people don't like to talk about. Either don't have time, whatever. They don't look at it as that important. But anyway, we're talking about the will. I'll say the definite article, probably, and again. This discussion is going to hopefully send some good messages out, and people can take the information and really digest it. Okay, but let me back up a little bit. I'm your host, Ed McQueen, of course, co-host Miss April Garner Davis. April. We have with us, we're going to get right straight to it, okay? We have with us a guest, I'm going to say backed by popular demand. Okay? Right?
Yeah, he's one of our favorites. Yes, he's one of our favorites and one of our audience's favorites.
Yeah, apparently.
He put us on the map.
Yeah. Yeah, you put us on the map. Hey, let's not talk too soon now because he might charge us. He's a lawyer, right? might charge us a lawyer. All right, Mr. Graham.
You never know. He might charge us an appearance fee.
And we're talking about none other than Attorney George Graham of the Graham and McIver law firm right here in Conway. And we're happy to have him. Are you all right, brother? Can you hear us?
I can hear you, and I am certainly glad to be here. It is my pleasure.
Good. Yeah, fantastic. You've been doing okay since the last time you spit out all this information that everybody got for free?
I'm blessed. I am really, really blessed. I've been doing very, very well. Thank you for asking.
Yeah, well, you look well. You look really well since the last time we met. But anyway, Attorney Graham, I think most people know you, but if you want to introduce yourself in terms of what your attorney that's specializing in, that's fine for us. I think some people would like to know that. If not, we just assume that everyone knows. And since you're so popular anyway, since the McIver Graham law firm is so popular anyway, just.
Yes, my name is George E. Graham.
Okay.
I practice law with the law firm of McIver and Graham in Conway, South Carolina. We are located on Highway 378, and my partner, Mr. McIver, and I have been practicing law together since January 1, 1981. We have an associate attorney also practicing with us, who is my niece and Mr. McIver's daughter-in-law, and that's Angela Graham McIver. The three of us do our best to provide as good a legal services as possible together here in Conway.
Well, you must have been doing something. You're very sustainable, so you must have been doing something.
We're blessed.
Yeah.
Let me put it that
Besides
way.
that.
We're blessed, and thanks be to the people of Horry County for those blessings through our God.
Absolutely. Absolutely. Can't leave that out. So, Attorney Graham, whatever you're going to say is going to be terribly important, I know. So what would you like to start off with? I think as our we were prepping for talking, you mentioned a number of, well, at least 2 or 3 things. And number one was the power of attorney, and then the health of the power of attorney. Correct me if I'm wrong, yeah. And then what's called the will and the estate/estate cessation. Okay.
Yes, there are as I understand, our topic is something about legal protections for your estate.
Right.
And I want to talk directly about those things. I'm going to talk about 3 different documents, and then I'm going to issue a challenge. And after the challenge, I'm going to bring in a new concept that I think everyone ought to be aware of and look at. The 3 documents that I'm going to talk about is a power of attorney, healthcare power of attorney, and then a will or a will/non-will, whether one dies intestate or whether one dies without a will. Let's talk about the power of attorney first. Let's talk about what that does. A power of attorney is when you give another person the authority and the right to sign for you. Now, that can be for anything. That's not what I'm talking about. What I'm talking about is a healthcare power of attorney that will help you to protect your estate. And because you are sick or temporarily out of your mind or in a coma, your property does not suffer. Your estate does not go awry. Please note, the document that I'm talking about is a durable power of attorney. There's a difference between a power of attorney and a durable power of attorney. A durable power of attorney is good no matter what happens. A regular power of attorney is only good for the specific purpose by stated in the document. For example, if I give someone the power of attorney and I get in an automobile wreck and I lose my lucidity for 3 months, if I have a regular power of attorney, it will not work. But if I have a durable power of attorney, it works. We see this often when we've got an elderly person living pretty much alone, taking care of his or her own affairs, and they have a stroke. And when that stroke comes, that person loses his ability to think, communicate, or do anything. If he does not, he or she does not have a power of attorney, that means have not assigned someone to take over their affairs and deal with their business, then what happens to the business? How do the bills get paid? If there's no power of attorney, the only alternative is to go to the probate court and ask the probate court to appoint a guardian or appoint a conservator. That can be rather expensive. When you're talking about going to the probate court, asking the probate court to do that, you're talking about in excess of $5,000 and maybe much, much higher than that. The cost of a durable power of attorney is minuscule compared to what you would pay to have the probate court to appoint someone over your affairs. And that's what happens. Now, when a power of attorney is prepared, it should cover a variety of things regarding your business, your bank account, your affairs, and things of that nature. Please note that the doable power of attorney under South Carolina law has to be recorded in the Register of Deeds office. That's the first document. Let's talk about the second document. The second document is referred to sometimes as a living will or a healthcare power of attorney. What that does is it gives directives regarding you in the event that you reach a stage where the doctor says, well, really it's pretty much his time, and they have to put you on a ventilator. The health care power of attorney gives the doctor instructions as to what you want to happen. Now, before I get into the healthcare power of attorney and what that's about, let me tell you the big preventative thing regarding the power of attorney. The power of attorney will stop, cease arguments in the ICU waiting room among your children. Because the question is, do I hook daddy up to a ventilator or do I not? Please note, in that healthcare power of attorney, there are certain things that you can do or direct or not direct. For example, the first thing is there is a donor clause in there as to whether you want to donate an organ or not. That's the first thing. You can say, I do not want to donate an organ, or I do want to donate an organ in that healthcare power of attorney. The second thing it does, it says whether you want to be hooked up to a ventilator or not. And a ventilator is nothing but a machine that helps you to breathe. It supplies the body with the sufficient oxygen for it to continue to operate. The next thing that it does, it tells the doctor whether you want to have a feeding tube hooked up to you or you don't. And then the fourth thing it can do is say, I don't want to be bothered with that. I want to leave that to Mary, because Mary will have an opportunity to discuss with my medical professionals my chances of making it or whether I should go on home to be with the Lord. That's what the healthcare power of attorney does. Now, the reason that is so important is because there won't be an argument in the ICU waiting room regarding the kids, because you will know what mom or what dad wants to happen at that time. Okay, that's the healthcare power of attorney. The next document is the will. And man, we can be here all night talking about the will, but let me say this about the will. What the will does is it disposes of your property the way you want it disposed of. The will says that I want this to go to that person and that to go to this person. There's a simple will where you simply say, I want it to go to all my children together. Or there's a complex will where you can say, I want the sewing machine to go to Mary, and I want the dog to go to James, and I want the horse to go to Betty. That's a complex will. So you can do pretty much however you want your property disposed of when you die. Please note that the doable power of attorney is a living document. It operates while you are alive. When you die, the power of attorney dies with you. The healthcare power of attorney is a living document, but a document while you're disabled, because you can't make those decisions for yourself. And what the healthcare power of attorney does is says, okay, in the event that this happened, this is what I want to happen. And I want Mary to overrule that decision based on conversation with the doctor. Or you can say, I don't want Mary to overrule anything. I just want to go on if it comes to a ventilator or a feeding tube.
Attorney Graham,
Mm-hmm.
I do have one question. So durable power of attorney, healthcare power of attorney, is it necessary to have both?
Yes. Yes. A durable power of attorney tells everybody in the world that this person can handle your affairs. The healthcare power of attorney is a directive to the medical people. In fact, you know how when you reach a certain age, you do your hospital package.
Mm-hmm.
When I see a hospital package, you put toothpaste and that stuff in a deodorant in a bag and set it in the corner and say, if I got to go to the hospital in emergency, this is the bag you take. Mm-hmm. Well, you would want to put your healthcare power of attorney in that bag, so when you go to the hospital, it would be accessible to the doctor. Mm-hmm. And if it's not there, he's going to ask about it. That's the first thing medical people want to know now, particularly since medicine has advanced such a stage where you can say no to this, yes to that. Mm-hmm. Okay.
Let me kind of regress a little bit back to the complex power of attorney. You mentioned saying that if you gave 3 of those items, you mentioned that the dog's on to James and the cat's going to whomever. But
you mean the complex will? Complex will,
yeah. So what's so complex about that? If you already specified what each thing is going to each person.
Well, you can do that for every item that you own. You can have a 3-page will, or you can have a 45-page will, depending on what you have. If you want to break it down and give it every little thing, or you can say, I want the furniture to go to James, rather than I want the stove to go to James, I want the living room sofa to go to Mary, I want the end table to go to Susie. So you can make your will as complex as you desire, or you can do a simple will. Of course, a simple will costs a lot less than a complex will, because a complex will is going to be based on the number of pages and how difficult it is to put together to comply with your wishes.
Right.
Okay. Now, if a person does not have a will, let's talk about what happened to his affairs or his estate. If a person has a will and that person leaves that item here, then of course the will determines where it will go. If a person does not have a will, the law determines where it will go. There is a statute, and that statute is based on a concept called intestate succession. And if you do not have a will, there's a South Carolina statute that says where your property will go. Let me give you an example. Okay. If a man dies and leaves no will and leaves a wife and children, half of his property goes to his wife and half go to his children together. If he leaves no will, leaves a wife and no children, all of his property goes to his spouse. If he leaves no will, no wife, but children, it goes to the children together. If he leaves no will, no wife, no children, it goes to his parents. If he leaves no will, no wife, no children, no parents, it goes to whole blood brothers and sisters. And it keeps going down the line, down the line. And if there is no relatives, it ends up cheating or going to the state of South Carolina.
So that's like leaving heirs property then, right?
Well, yeah, it is leaving heirs property, because when it gets so far down the line, it becomes heirs property. And that's a point that I want to make. And thank you for bringing that idea up, because we do a lot of heirs property. Heirs property can be prevented by people diligently going to the court when someone dies and either probating the will or probating that person's estate without a will, because legally his heirs are determined in that probate process, and the property usually won't turn into heirs property. Now, I say usually won't turn into heirs property. So if that person leaves 5 children, the law says that those 5 children will take. But if one of those children dies, then that estate got to be probated, because if you don't probate the estate, then you're looking for heirs property. And I'm going to tell you, if you got an heirs property situation, don't wait until it gets too huge, because if it gets huge, the big beneficiaries are going to be paying the court costs, paying the lawyer fees, and then the family gets what's left. All of that would be unnecessary if a person diligently probates his or her estate. Now, I've talked to you about 3 documents. Let me talk to you about one other thing that's probably more important than the 3 documents. Please, please, please always have that death discussion. Stop playing games. It's not if you're going to die, it's when you're going to die. Have the discussion, parents, with your children about your dying. You don't have to tell them what's in your will, but tell them, I've left the will, and what's in my will is the way I want things to go. You cannot be forced to change your will under any circumstances. Your will disposes of your problem, of your property. It ought to be your decision, because you've earned the property. So you get to dispose of it, not your children. But if you have that death discussion, I guarantee you, where the lawyer sees argument after argument among the children, that argument will cease. Okay? So, doable power of attorney, healthcare power of attorney, or living will, and then a regular will, whether it's complex or simple, and then the death conversation. Please have that conversation. Please.
A lot of people don't like to talk about death.
Well, yes, we don't want to talk about death as if it's not going to occur. It's going to occur. It's not if, it's when. And we, for some reason, think that because we don't talk about it, it's not going to happen. It is going to happen. And you ought to have that discussion, not for you, but for the ones that you're going to leave here, so they don't have these bitter discussions, name calling, and division among your benefactors or the people that you leave in the will, or if there's no will. Even if you're not going to leave a will, still have that death discussion.
Attorney Graham, I do have a scenario. So let's say Mama Jane decides that she wants to write down her wishes for her funeral, for her assets that she leaves behind. And that's what she has. She just has a piece of paper with all this written on it, tucked away in her chest of drawers or a little envelope somewhere. Does that particular document act as a legal document, or does it have to be recorded somewhere or notarized in order for it to be legalized? How I think sometimes people leave behind their wishes and it doesn't necessarily act as a will or a document with full understanding of, what's supposed to happen. So how does a person go about making sure that they have something recorded that is legal and binding, or that should be an authorized statement of what it is that they wish upon their death?
That's an excellent question. That's an excellent question. What you're teetering on is what we call a holographic will. A holographic will is a will that is written solely in the handwriting of the testator or the person that leaves the will. It must, however, be executed just like any other will that's prepared by a lawyer to be valid in South Carolina. So writing it out and signing it won't do it. You got to have the witnesses there. Okay. So write it out in your own handwriting if that's what you want to do. But you still need to have your two witnesses and a notary.
Yeah, and that answers Paula Vereen's question. Paula, thank you for watching tonight. Is it true that the will has to be notarized with two witnesses?
Yes.
Okay.
Now, any other questions regarding power of attorney, healthcare power of attorney, wills, or the death conversation?
So when I do want to go back to the power of attorney that we were talking about earlier, that's related to healthcare. And I think that's the one where you said it will stop arguments in the ICU waiting room. And you were leaning into the fact that families need to have the death conversation, because you're right. When you go into those types of situations, and again, Mama Jane has named, her niece to be the executor or whatever, the power of attorney, whatever you call it. I think that
personal representative.
Personal representative, that's where I'm going. Personal representative, it might stop the arguments in terms of it, the finality of it, meaning if a doctor is asking a question, only, Nisi can answer that because she is power of attorney, or she can give the definitive response to whatever the doctor is asking. And I think that families miss the boat on that, because these conversations are not happening. And yes, these arguments are very real and they're happening in the ICU. So what's your best advice on how to even start the conversation? Because I can imagine that around the table, somebody's going to be mad because Nisi was named as the executor. But if that's what Mama Jane wants, that's what Mama Jane wants. So how do we even begin these conversations? I'm sure there are people who are watching who are like, yeah, we need to have the conversation, but how do we start?
Here's what you do. The people who are most important to you on this earth, set them around the table and be honest and straight up. And you start out by saying, it's not if I'm going to die, it's when I'm going to die. And when I die, or if I go to the ICU waiting room and they're talking about a ventilator or a feeding tube or donor, do I want to be a donor? These are my wishes. Don't let anybody get up and leave and say, Mama, I don't want to hear that. Or Daddy, you're just talking out of your head. Express to them that I'm having this conversation not for me, but I'm having this conversation because I love all of you. And I want all of you to understand straight up what I want and where I'm coming from. So you don't have to ask anybody else what my thoughts are. I'm giving you what my thoughts are, and have that discussion. And if that child or if that significant other care about you at all, he will or she will understand what your wishes are and respect your wishes. Then, when you're sure wanting the lawyer to read the will or wanting the lawyer to talk about what happened, the lawyer doesn't have to say, well, that was her desire, or that was his desire. The only thing you can do if you don't like it is go out to the cemetery and have an argument with him. That's how it works, because that person worked hard to acquire what they acquired, not you. And that person ought to make, the law says that person makes the determination as to where that goes. Now, let me say this. When you do a will, a man can't disinherit his wife.
Ooh, get into it. Let's get into
When
it.
you make a will, a wife cannot disinherit her husband.
You want to
If
stay into
you
it?
disinherit your spouse, there's a South Carolina statute that says that spouse can take an elective share of 1/3. Please note something else about South Carolina law. If you got yourself a lover, you can't give that lover any more than 1/4 of your estate. Your wife can always get 1/3. Your husband can get always get 1/3. The paramour can only get 1/4 by will. Right? So the paramour will never get as much as the spouse.
Brother Edward, he might be stepping on some toes. But that's a real conversation right there.
Look.
I would like to deal with one more concept that affects all of this, if I may. And that concept is legitimacy. That concept, or the definition of legitimacy, is as follows. When a child is born during a marriage, that child is legitimate. If the parents are not married when that child is conceived and they get married after that child is born, the law determines that child to be legitimate. When you go to the court and ask the court to determine that this person is the father of that child is legitimate. When you probate an estate and that child was born out of wedlock, and somebody goes and asks the court to legitimize that child through certain vehicles like a birth certificate or something of that nature, that child becomes legitimate. Now, let me tell you what illegitimacy does to a child. Okay? That's running rampant in America. And it's the two people's business that whether they have sexual relationships and create an illegitimate child or not. That's their business. I'm not talking about that. I'm talking about when it happens, understand the consequences of what happened. An illegitimate child in the state of South Carolina does not inherit from the father unless certain things happen. An illegitimate child inherits from the mom because, of course, people can see mom with a baby. People can see mom taking the child to church. People can see mom taking the child to school, but dad may be in another city. Okay. So you got your affirmative observance that mom is the mother of that child, but not dad. Because if a man is hanky panky, tell you what he's not going to do. He ain't going to come home and say, I was out there hanky panking. And if a child is born as a result of that, what's the consequences for that child? Okay. Mothers are correct to require dad to pay child support. When you go to domestic court, before the court will require someone to pay child support, it has to be adjudicated that he is the father of that child. And once the court determines he's the father of that child, then of course the court's going to require him to pay child support. That's enough. So when father dies or father gets killed in an automobile wreck or something, there's money coming from that. That child who was illegitimate is now legitimized, and that child takes just like the father's other children. Please, please be careful with that. Okay. Now, when father dies and the state is probated, there's an opportunity when it's published in the paper. There's a 8-month waiting period by which you can go to probate court and tell the probate court that he had another child and this child. And if you can prove that under South Carolina law, right, then of course the court will say that that child takes a share just like the legitimate children. The children that are illegitimate did absolutely nothing to get here. But they shouldn't have to sacrifice property left by their dad that's given to legitimate children because mom or dad don't take steps to make sure that that child is protected. And that's what I'm talking about when I say take a second look at legitimacy and illegitimacy, so that child doesn't sacrifice who had no say in whether he's here or not. Don't punish that child. Treat him just like you treat the rest of them from a legal perspective. The other thing is, if the daddy dies, that child is entitled to Social Security benefits. You will have problems if that child has not been legitimized, getting even Social Security benefits. Then if you listen to doctors, they say that illegitimate children have poor health at birth. And if you listen to the early childhood educators, they're going to tell you that they have delayed development in school and have poor academics in school. So just because the child is born illegitimate doesn't mean that that child ought to continue to be punished for something he or she had no say in. Parents, please consider that and do what is right by the child. And that has effect in domestic court. It has effect in probate court and who gets what, right? So if you love those kids, grandma, if you love those kids, make sure that that daughter or daddy do the right thing by those kids by making sure that they get resources from both parents, not just one parent.
But this is everybody. It's quiet as a you can hear a pin drop. But
Attorney on my side over here.
I know that's right, Attorney Graham. You do an excellent job of explaining everything in what I would consider as layman's terms, and makes me feel like I can go out and be a pseudo lawyer just by, repeating what you said, because just like you said, within society, within our communities, even, there's so much of this that's going on, and there's always so many questions. There's always, that chance that there's going to be some divisiveness in families when it comes down to the legal situations that we face. And I even dare to say that within the Black community, there's a huge lack of education about all of this. So this is something that, we need to continue to bring to our communities. I don't know if we need workshops or whatever we need, but I learned something today. And I'm sure that there are others who have plenty of questions, because some of the scenarios that you mentioned, they run rampant within our communities, and we don't know how to reel it in, and we don't know how to deal with it when we're faced with our probate matters. And Brother Edward mentioned heirs property, and I know that that's a really, really big topic that we don't have enough time for tonight. We'll have to bring him back, Brother Edward, bring back the program to dig deeper into that. But as we, as we think about all of the, the legal procedures and best practices, I think that one of the things that we have to always remember is that if we don't move proactively, as you said before, then, the problems just get bigger and bigger and bigger. And so we can't be afraid to actually ask the questions, to sit down with our brothers and sisters, to have these conversations, to sit down with, mom and them, to have the conversations. And, also just, we just have to learn how to protect ourselves better, because, there's a scenario that I know of. And what was crazy about the entire situation was that you had someone who had power of attorney. They didn't really understand what that meant. They thought that power of attorney meant that they, had power over everything, even after the person died, right? And you brought up earlier, power of attorney dies with the person, right? So person has said bank accounts, for example, and, a name or two on a couple of different bank accounts. Well, person with power of attorney says, it doesn't matter, I've got power of attorney. And they, did not understand that, it does matter, because once the person died, power of attorney was no longer even in force. So they didn't do certain things to ensure that, the finances were not accessible by other individuals who were moving in a way that wasn't in the best interest of the person. And that kind of thing is just, it happens every single day, so we need more education on this kind of thing. And it always leans into the financial piece, the estate, the home, everything. And even the illegitimacy, that part is really big, because, that's a very real thing. Bonnie Edie, when you were talking about, the lover in the equation, she asked, what if they are legally separated, meaning the husband and wife, and maybe the husband has a lover? Does that even matter if they're legally separated, and let's say the husband decides he wants to leave something to the lover that he's in the hanky panky with?
He cannot leave any more than 1/4. And law's design that gives a 1/4 is less than a third.
Mm-hmm.
So he can't give but a fourth. Now, his wife or his spouse can always take a 1/3 elective share. And all the mathematicians are going to tell you that 1/3 is always larger than 1/4.
Mm-hmm.
So do you think the South Carolina designed this to repel or deter having illegitimate children?
Well, let me say
because one time that was a taboo for a young lady to get pregnant.
Well, okay. When I was in law school a long time ago, illegitimate children could not inherit from the dad, period. The Supreme Court changed that rule because it's not fair. The child had nothing to do with that. So it's not fair.
South Carolina Supreme Court.
No, I'm talking about the U.S. Supreme Court.
U.S. Supreme
Changed
Court?
it
Okay.
and said that in this nation, illegitimate children can inherit from the dad. But that concept called states' rights that everybody want to talk about, it says the state will allow the inheritance of illegitimate children from the dad, but the state can put forth certain rules that they require.
Mhm.
And that's what South Carolina has done. Put forth certain rules that they require so that illegitimate children have the possibility of inheriting from the dad.
Mhm.
Okay. So just because somebody point to me and say that's my dad under South Carolina law, that does not make me that person's dad. You have to go a step further. And I'm saying what the darling of one of the things is that moms have realized that it's not their responsibility to just take care of the child. So they ask the court to require dad to pay child support. The court's not going to require dad to pay child support unless that guy is adjudicated to be the father of the child.
Mhm.
Once that occurs, that child is not illegitimate in the sense that he can't get from dad anymore. That's dad's child. That's one of the requirements that South Carolina law has. The second thing is you can, of course, go to probate court after dad dies and try and establish parentage that way, right? And the jury is out on whether dad signs the birth certificate. Does that make him or not? I don't think it does, right? But what you can do, what women ought to do, is make dad sign an affidavit or a statement saying he's the father of the child. While times are good, dad's still talking to you, make him sign that affidavit, then your child is protected. And that's what you're trying to do, is protect the child.
Protect
You're
the
not
child.
trying to cause any animosity or hardship between the parents. What you're trying to do is protect the child. Say, for example, there's an illegitimate child there, and dad gets killed by an 18-wheeler, and dad has 3 legitimate children and 1 illegitimate child, and there is wrongful death monies. That wrongful death money will be shared by those 3 legitimate children, and the illegitimate child gets nothing.
Whoa.
You got to preach to me
Really?
every day to convince me that that's fair. It's not.
Mhm.
And if mom or grandma or granddad or dad, if they're not encouraged to do it and they don't do it, we don't know how we're going to leave this earth. We're going to leave. And if we leave via a wrongful death or something like that, where this money's coming, that illegitimate child will not take, because he's not dad's child under the statute. Is the reason we ought to be concerned about this concept.
Mhm. There's a question from Sandy Pick. Sandy, thank you for watching tonight. And the question is it advisable to have a backup POA if something were to happen, basically to the person who is the power of attorney? So should you have 2, I guess, or more, or 1 or more, you know?
Yes, and yes, you should. And that's called an alternate. So you would name a primary one that would make the decisions, and then you certainly can name an alternate in the event that the primary one cannot do it. For example, husband and wives should always consider naming each other, and then the business-minded, trustworthy child should be named as the alternate.
Okay.
But
We have a
but
couple.
it still follows the demise of the person, right?
Yes.
Yeah. Okay.
Yes.
Mhm. Mhm.
Yeah, That's a good question.
Mm-hmm. So a couple more questions here. Bonnie Edie asked, when the wife does probate and leave the other kids out, but the father paid his child support and claims them, what can the kids do to get their share of the estate?
Oh, and that's why you got that. You when you probate an estate, the first thing that happens after you file your application with the probate court is there's a publication in the newspaper.
Mm-hmm.
And that publication in the newspaper tells who the personal representative is, and it tells who the lawyer is of that estate. And if there's a question about whether that child is included or not, that person should contact, if he doesn't have a lawyer, he should contact that lawyer and or the court about filing a petition to be determined that he is in fact the child and he will take a share. Yes, that's an excellent question.
Okay. Paul Marie.
And let me say this.
Mm-hmm.
Let me say one more thing. Guys, we see probate in the legal notice section. We don't read the legal notice section. We ought to read that. Do you realize if a person wants to sue you for any reason and he cannot find you, he can publish it in the newspaper and it's going to show up in the legal section. If you don't read the legal section, then you won't ever know it.
Wow.
But the law says everybody read the newspaper.
And you know what? That's becoming even harder these days with newspaper.
Yes. Yes.
So then you have to, I guess, rely on what's published on the web. So yeah, wow.
But the Sun News is still out there. Ori Independent is still out there. North Times, all those guys are still out there.
Mm-hmm. All right, we have another question. Can the court strip someone from power of attorney status? Ooh,
yes.
That's a good one.
Yes, the court can strip you of power of attorney status if you're not doing what you ought to be doing or abusing your fiduciary relationship, which is created by a power of attorney. Anytime there's a power of attorney, then that person has a fiduciary relationship with the person giving him that power of attorney. That's why you ought to try and resist that person giving you something while using that power of attorney to get something from the person you're representing. Just stay away from that. The court can, in fact, strip it from you.
Well, you may not. I don't know. You may not know this, but give me a typical example of an abuse, if not an abuse, something that that courts can strip the power of attorney from. I mean,
yeah. For example, let's suppose that I give you my power of attorney because I'm in Philadelphia, and when I get back from Philadelphia, I learned that you've used the power of attorney to go to my bank account and withdraw $1,000. Okay. And you take that $1,000 and go put a down payment on a car. That's not abuse?
Yes.
If it is, I can ask the court to rescind that. Or guess what? When you got a power of attorney, it isn't all ironclad. I can rescind it. It just has to be rescinded in writing. So I can rescind it and then turn around and sue you to get my $1,000 back. Yes. And if you don't want to give it up, then that's where you get the court to come in and strip you. A lot of times where you see that abuse taking place is when the person then become not lucid, right? And can't rescind the power of attorney. Then someone, say a family member, can go to court and ask the court to rescind the power of attorney because of you abusing the person. Yes, that's a good question.
Wow. Well, April, it's I hate to even say this is like discussing your demise with your family. Tell me, when you're gonna die, because our time is almost up for this broadcast. You know, I'm I'm comparing those two. Um, yeah, this information is so, to me, is so critical and valuable that yeah, I don't know what else to say except that and you got some in these comments, man. These comments, people are just coming in and asking legitimate questions, and so it must have been um, it must have touched a lot of people in terms of they've been in situations like what you were discussing.
Mhm. And listen, my parting comments would be this: uh, everybody works hard to acquire what they acquire. Just be sensible in its disposition. Make sure it goes where you want it to go.
Mm-hmm.
And the way you do that is by following the rules that's set out in the law. If you don't follow the rules that's set out in the law, then you're going, as April indicated, you're going to heirs property situation. And that's a whole different ball game.
I think that needs to be our next conversation.
Okay, but April, somebody, I'm getting comments from on my text here that's coming, and one of them is, it says that here it goes. It says, oh wow, do you still have to go to probate having a will after the person dies? I mean, I think we answered that. I believe.
Mm-hmm.
Yes,
He
you
did.
do.
Mm-hmm.
Yeah.
Yeah, yes, you do. Now
Mm-hmm.
listen, okay. Whenever you go to a lawyer to do a will, there's one thing that you need to always be mindful of. That lawyer needs to talk to you about estate planning. You can plan the disposition of your estate while you are alive and do documents to fix that so that after you die, there is no probate necessary. But that's a whole
Mm.
different concept, because when people go talk to a lawyer, they won't talk about estate planning. They'll walk in and they'll talk about, I just want to do a will. Because a will doesn't take effect until a person dies. But there are things that you can do while you are alive to dispose of your property the way you want it disposed of anyway. Let me give you,
Well,
for example, okay?
Mm-hmm.
Let's say that there's a mom that has 10 children, okay? And the mom has a house. And the mom says, I want all of my children to have access to this house. So I'm going to leave a will. Mom can do that. Or, mom, why don't you think about retaining a life estate for yourself, which gives you the right to this house as long as you are alive, and then give the remainder to all of your children jointly with rights of survivorship, so that no one can put any of your children out of this house as long as they are alive. And the last person to live, which you don't know which one that's going to be, will end up with the house. That's estate planning right now and there. And then when mom dies, her life estate is gone, and the last child to live out of the 10 children will get the house. You don't know who that's going to be, because only God knows that.
Attorney Graham, I'm glad you mentioned that rights of survivorship. Is that something that should be noted on the deed to the house?
Yes, that's where, and that's what I'm saying. The mom could do a
Mm-hmm.
deed. The
Mm-hmm.
remainder, I
right.
reserve a life estate for myself. I'm giving it to my 10 children and name the children. the remainder to my 10 children after I'm gone.
Right.
And each of those children will have the right to possess and own that house. And if they want to sell it, all of them get together and sell it, right?
Right.
The last child to live will end up owning the house. And there is no probate involved because mom did that while she was alive with the deed.
Yeah, that deed. Yeah, that deed is a critical piece of document.
It is. It's critical, and the reason why I ask is because again, we don't know that, and then there's always that issue that crops up, and unless you know, if you're living through the experience, unless you know to make sure that term is on the deed or add it to it or whatever, you have to remember. Like my parents, bought their home maybe in the 70s, 60s, or whatever. They probably weren't educated on making sure that when it was passed down that the rights of survivorship were intact. And so, and I'm sure that, there are other families that are dealing with that as well. And so, I learned about that and, thought to myself, wow, who really knew, and who knows, when you're trying to deal with all of the legal procedures, upon a parent's death or whatever the case is. Paula Vereen wants to know, where can you acquire the power of attorney documents? The courts, online, where can you get them?
The best way to do it is to get a lawyer to prepare them, because the lawyer needed to make them specific to you and what your situation is. A lot of people go online and pull the power of attorney, but that's going to be just generalities. It won't be specific to you. So be careful when you do that. I'm not saying that you can't do it. I'm just saying be careful when you pull them offline and all you're going to get is something general rather than something specific to you.
Attorney Graham, when can we bring you back to talk about heirs property?
Whenever
I mentioned that a few minutes ago, and my phone is blowing up.
You also said my next appearance, I'm going to have to charge you a fee.
Take that back.
Can we talk about that offline? Can we?
take that back.
I would be very, very happy to come back and share with you heirs property. That is a concept that's just hurting our community to death. And you would not believe, as forward thinking as Horry County is supposed to be, you would be surprised how much heirs property actually is clouding up our property here in this county.
Wow.
Yeah. Okay. Look, after this, we're taking a lot of your time. I'm still getting these emails. Okay. I mean, I'm sorry, not email, but text. And here's this person that says that you may have to straighten this out a little bit. Say, can you leave two of the children's name on the will for the house, but the other children have a right to the house?
Yes, you could word it in such a way. What you could do is, what one could do is give the other children a lifetime right to the house, and then give those two children the remainder jointly with rights of survivorship. Then it ends up in the last child's name anyway.
Okay.
Yes,
okay.
That could be arranged. You could do that.
Okay. I think this is a case where the parents have been deceased, and then the second to the last child has been deceased now. So there's only one person that's being left, I believe.
Oh, if there's only one child left, all you need to do is that estate, depending on the document or the deed, that estate may not need to be probated. All you would need to do, if it's joint with right of survivorship, is take a copy of the death certificate of the last child to the assessor's office, and then they will remove that person's name.
Okay. Yeah. Right.
Depending on what the document says.
Right. Right. All right. Co-host.
You already know I'm a fan. I'm a big fan of Attorney Graham, and look, he's gonna keep us in business.
Yeah.
This is just powerful information, and it's a very relevant topic. It will never not be relevant, right? So that's why we want to definitely keep the momentum going and bring you back. Brother Edward and I talk about when offline and, tackle heirs property. And for those of you who are watching, drop in the comments some topics you'd like for Attorney Graham to talk about. And, maybe, we can do this once a month or twice a month or whatever. Whatever's important to you is what we want to talk about on the show. And so, we just want to thank you for your time. And I'm sure we could talk all night about, all things legal. And I'm glad that you're willing to share with us your knowledge and your expertise. And like I said, you do it so well. And so we got to bring you back. And it was a pleasure to have you on the show tonight.
Hey, April, it's obvious to us now, even with the last broadcast, that, to our viewers, whenever you have a situation like that, one of the situations that have come up today, you can go by your office, right, Dr. Graham, where that's located where?
That is correct.
And that address is?
That address is Highway 2015, Highway 378, 2015, Highway 378.
2015, Highway 378.
Right.
In Conway, South Carolina.
Conway, South Carolina.
Remember now, you're worldwide because we're on Facebook also, okay? So,
okay.
All right. So we may have to hire some more people, man, get all this.
Well, I commend you guys. For keeping our community informed as to what's going on. I say nothing but thanks to you. Both of you have done a marvelous job informing our community with issues that are prevalent and need to be addressed. Thank you so much.
Well, that's the first thing we see. We see the need, and then we try to bring someone who can address that need for the community.
If I've helped in any way, I appreciate it. Absolutely. Absolutely.
Absolutely.
Well, thank you so much. And again, we'll touch base with you offline and see when we can have you back. So I hope that you have a great rest of the week.
All right.
All right.
All right. Good night, everyone.
Good night.
All right. Brother, that was some amazing information. And Attorney Graham is always just gracious and willing to come and educate the community. And so I hope everybody was taking great notes. This was a fantastic show, and we will bring him back. It's already in the making. We'll bring him back.
Key word here is what you just said, education. I think there need to be a forum to be developed so that you can have these forums at the different venues that we have locally or not so locally to educate the people on the value of wills and estate planning. Just based on the comments that are coming in, this is, it's really like Ms. Malone says, it's awesome. Stephanie says, it's awesome.
Well, and I think also the response to Attorney Graham shows you how much he's respected in the community in terms of his expertise and his knowledge. And, we were all listening attentively, just like we were in class, taking notes. And also, I think people have these questions. They just don't always know who to ask, in order to get the answers that they need. So we'll definitely bring him back. What I want to mention before we close for the evening, Whittemore Alumni Association scholarships. There are 4 scholarships available, 4 different scholarships that were developed this year, one of which was always in place, which is the Whittemore Alumni Scholarship, and the other 3 were developed as a result of some connections and relationships that were built throughout the community. The class of 1967 has a scholarship, the Willie Dean Whaley Teaching Scholarship. Atu Rue and his family have developed a scholarship as well. And then the husband of the late President Annis Austin Staley has set up an endowment, and it's a multi-year endowment. And the Atu Williams Scholarship for Matthew Rue, his grandparents, basically, is also multi-year. And so we had to extend the association had to extend the scholarship deadline to April the 29th. So there's still time. If you have a student who is a senior in high school and is in need of some money as they get ready to go to college, if they're college bound, go to the Whittemore Alumni Association website and check out the scholarships that are available. One of the scholarships, the Whittemore Alumni Scholarship, of course, is directly tied to the history in terms of the student being a descendant of a Whittemore graduate. But the other scholarships have their own criteria. And so you want to check out all of the scholarships to make sure that you qualify or that you meet the criteria. Your transcript is required, a couple of letters of recommendation. That's not hard to get from your, people in the community who can vouch for your character. And then also you need to submit a short video or an essay as a part of your application. So altogether, there's over $16,000 available to be distributed to students who qualify for the scholarships. And so the information is at the bottom. You do not have to live in Horry County in order to take advantage of these scholarships. And the thing about it is, if you are a descendant of a Whittemore alum or graduate, no matter where you live, you can apply for these scholarships. So I can tell you that, we have some scholarship applications in, and students are coming from all over the place. I mean, we have some as far as even Georgia, because they are connected to the history of Whittemore. So you might want to, ask your parents if you're a student that's watching, whether or not you have that connection to a Whittemore alum. Or if, you're a parent who's watching and you're not quite sure, you may want to dig into your family tree a little bit and find out if you have any relatives who came through the Whittemore system, and that's graduate or alum, meaning they graduated from Whittemore High School or they came through the Whittemore system. Again, that's the website, WhittemoreAlumniAssociation.org. Just check out the scholarship information. You may know a student who qualifies, and the deadline is now April the 29th for application. So I want to make sure we put that out there, Brother Edward.
Yeah, absolutely. Those are critical scholarships, and there's no use in letting them sit dormant. Okay. Mm-hmm. I mean,
money's on the table. Mm-hmm.
Yeah, they're putting it on the table. Okay, April, while you mentioned Whittemore, this past Friday, I believe, fantastic banquet was inaugurated by the Whittemore Race Pass Historical Society. And wow, Cookie Goins was the moderator for that. And a number of certain things. I mean, the membership of the Historical Society, it just did a fantastic job. I mean, it was at the Wild Wings, and anybody can tell you who went there because it was wall to wall. But anyway, that it was a great. I just want to commend the staff of that Historical Society. According to the comment that just came in, it was Saturday that this event took place, and guess who? They also I also use the word cherished. Was Miss Graham, Miss Sarah Graham. She's 100 years old, and she was there. She was there. I'll tell you, it was just phenomenal. But for all of those who attended and those who were coordinators of this, and including the president of that, Miss Cheryl Moore Adamson, with her family there. Mm-hmm. It was just fantastic. Just great. Just wanted to bring that up. Okay, we've had a lot of your time and everybody else's time, April. So, wow. Was it worth it?
Oh, it was definitely worth it. It was definitely worth it. It was definitely worth it. So,
yes.
Yeah, so we just want to thank everyone for being a part of the show tonight. Thank our audiences far and near. And we'll be back with another great show. And again, drop us a note. Let us know what you're interested in learning more about. And we'll do some research to see if we can find a special guest who can come on and, talk about whatever topics interest you most. And so just hoping that everybody will have a wonderful rest of your week, and be safe until we see you the next time.
Absolutely. Night.
All right. Good night.
Thank you for watching the World Community Magazine's Hour of Power Live on Facebook with your host Edward McQueen and April Garner.